Justices of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. Good morning. We're going to call a case out of order. We're going to call case number 647, City of Buffalo versus Carr first, if counsel is here.
Morning.
Is opposing counsel present, Gina?
I have not seen him.
Okay, we will, we're going to recall it then momentarily. Thank you. All right, best laid plans. We're going to go back to the original calendar. We're going to have to change our lineup of judges here. So please bear with us a moment. We had recusals on that last case. We will now call case 636, People versus Marcus Boone, 636.
43 with it, please.
Yeah, case 43. We're going to call them both at the same time.
Yeah.
Thank you. Good morning, Counselor.
Morning, Your Honors. May it please the court, Guy Talia from the Monroe County Public Defender's Office on behalf of Defendant Dolores Marcus Boone. I'd like to start with a point one, which is that Supreme Court erred in denying Mr. Boone's motion to dismiss the indictment based upon defective grand jury proceedings. As the court knows, Mr. Boone was charged with criminal possession of a weapon in the second degree. That statute prohibits possession of a loaded firearm.
Didn't the court rule on that though? Didn't you ask the court to review those the minutes, and the court did and found them to be sufficient?
It did, and that's when we're claiming that was an erroneous on its part to say that there weren't defective proceedings. So yeah, that's our whole argument on appeals, that the Supreme Court erred in making that determination. So as you know, the argument is that an element of that crime is not excuse me, Your Honor. So just
You're relying on Jones, and you're saying that his previous conviction is not an element of the CPW offense for which he was charged.
correct.
You don't know what the grand jury minutes say. You suspect that the prosecutor admitted evidence of a prior conviction, and that was improper under Jones in your view. That's essentially your general point, I believe.
Exactly, Your Honor. That's exactly correct. So an element of the crime is not, the prior conviction is not an element of this crime under these circumstances. And we have reason to believe, based upon the special information, and I think people actually conceded that there was evidence presented to the grand jury of his prior conviction. And we believe that they actually instructed the grand jury that the prior conviction was an element of the crime. And as we know from Jones, and it's confirmed by the third department on Taylor, it's not an element, and it was improper for, if that was done, it was improper for the prosecutor to introduce that evidence in the grand jury proceedings.
So it's really just a question of, does this go to the integrity of the grand jury proceeding? Because your client pleaded guilty. And there's the law, as you know, if you plead guilty, certain defects are waived in the grand jury. And is this one of them or not?
Correct. Yes, and we argue that it's not forfeited by the guilty plea because it was something that it's a constitutional problem that goes right to the heart of the integrity of the process, and that is a due process violation. We only have to prove that there was a potential for prejudice, and this error, is a constitutional issue in that it's propensity evidence. It's evidence that jury could indict based upon retribution. So yeah, the people say that there's basically two forms of defective grand jury proceedings: evidentiary and jurisdictional. But they fail to point out that there is a third prong, which you mentioned, Justice Lindley, that if it's a constitutional issue that goes to the fundamental fairness of the process, that is not forfeited by a guilty plea. That's made clear by the Court of Appeals Hanson and Morel, and that's exactly what this is. If you're presenting evidence of a prior conviction completely unrelated to the charges that you're bringing before the grand jury, that's clearly under a century of our precedent. A no-no. I mean, you can't be presenting prior conviction evidence that's unrelated to the crime that you're presenting.
Well,
To the grand jury.
it's not an element, but it is part of an exception. It's an unusual statute. It seems like it's CPW third if you possess a loaded weapon, but not if you're in your house. It's not a crime under that statute. But then again, it is if you're in your house and you have a prior conviction. Here, it was obvious the guy was in his house when he was arrested. So I get why the prosecutor, if he didn't put in, let's assume that he did for the sake of argument. I think they conceded it. They didn't put in the prior conviction. You might be here arguing, hey, the evidence was insufficient because he was in his house.
I mean, that may be an argument to be made, but it would be wrong because the Court of Appeals has made absolutely clear that it's an exception to an exception. So the exception is that if you're in your home, then it's not a second degree violation for possessing a loaded firearm. But an exception to that exception is if you have a prior conviction. I agree with you, Honor, that's a very unusual statute. It's very poorly worded, but Jones made it clear and in no uncertain terms that this is not an element. And I think there may be some confusion in terms of whether, CPL 260 applies and you could present a legally sufficient case, but I just argue it's incorrect. There is no 260 procedure for this statute after Jones. And I guess, the way the defendant can keep it out is just by not raising the in-home possession as a defense. So that's what you would do. I mean, if defendant, is going to testify at the grand jury or raise in-home possession as a defense, then the people can bring the evidence in. But if they don't do it, they get to keep that all out. And it was improper for them to do it because there's no evidence here that my client raised as a defense that he was in his home during the grand jury.
I think we got that point. Do you want to move on to your second point on that or to the other appeal, 643? 643.
Yes, thank you. I move on to my second point in this case, which is that there is ineffective assistance of counsel for not raising a meritorious speedy trial claim. So it's well settled that the failure to make a meritorious motion in and of itself can amount to ineffective representation. And we know that it affects the guilty plea, about the voluntariness of the guilty plea, because had our client known that there was a meritorious speedy trial violation, it definitely would have affected his decision to plead guilty. So the question here is whether it can be determined on this record whether there was a meritorious speedy trial claim, and we think that this record definitely shows that it was. People inexplicably 9 months late disclosed Giglio materials. It was in existence the entire time. It was in their possession the entire time. It wasn't protected under civil rights law, which had been repealed by that point. All of the officers were potential witnesses up at the time that it was disclosed.
Isn't it your point that there's no explanation for this reasonable delay being made? And there's supplemental
no explanation given, nor do we think there could be. People suggest that, we can't tell them the facts, whether they may have come up with a reasonable explanation.
But weren't the statutory obligations not in effect at this time?
No, this was
requiring that. I mean, they weren't put in effect until May of 22, excuse me.
Well, this is a new discovery statute, but I think you're referring specifically to the obligation to explain the delay with the supplemental disclosure. I believe that may have come into effect a little after this, but the question is whether the initial certificate of compliance was proper or not. That the properness of the certificate of compliance under the new discovery law was in effect, and we're arguing that it was improper because they had all of this stuff at the time that they issued that initial certificate of compliance, and they didn't disclose it. And we don't think that there's any way they could say that they did due diligence or made reasonable inquiries, because any amount of due diligence or reasonable inquiry would have produced this information. So its absence alone, we think, shows that there was no due diligence involved. So it's not necessarily that they didn't explain the supplemental. It's just that the initial certificate of compliance was invalid to begin with.
We have to determine not whether there was a discovery violation, but whether it was such a clear-cut discovery violation that counsel was ineffective for failing to bring a motion, and we're going to take a look at that. Do you want to touch on 643 before your time expires?
Sure. With respect to the other case start with my point one again, that Supreme Court erred in denying Mr. Boone's motion to suppress based upon the invalidity of the search warrant. So he clearly made a motion to suppress. He challenged the validity of the search warrant, thus putting the people on notice that they needed to establish the legality of it. The probable cause presumption disappears once that challenge is made. The initial challenge was based on the fact that the warrant was not based upon probable cause. And then later there was a challenge to the validity of the warrant on its face because of the issuing court was not clear.
Is the issue there, do I understand your argument correctly, that the warrant of arrest from Judge Argento was insufficient, legally insufficient, because under the CPL, it has to identify the local court that she was sitting in at the time?
Correct.
And
Yep,
she signed it, she crossed out Monroe County Court, but that's not even a local court, right?
correct.
And she wrote in New York State Supreme Court. And your point is that she was sitting in local court, either city court or town court. She needed to sign it in that capacity?
Correct. Either she needs to sign in that capacity or somewhere it needs to be listed on the caption. The caption listed county court, not a local court either. Perhaps if she signed it, if that was the only problem, but if the caption listed a proper local court, may be overlooked. But here there was nothing on the face of the warrant at all to indicate the local court that it was issued out of. The
Well,
caption.
there was another warrant from Judge Cassara on a VOP. The people relied on that below. If we agreed with you that the Argento warrant was insufficient and therefore didn't support the warrant here, should we not remit to see if the warrant was valid, the other warrant was valid?
The people advocate for a remittal based upon to consider the validity of that warrant. Under normal circumstances, I think that could be an appropriate remedy, but here I don't think it's appropriate because the people abandoned the reliance on that warrant basically below. They stated it initially very early on. They said, "Oh, this is based on two warrants." Then months went by, several appearances went by. The court was asking all the questions about the Argento warrant, and nobody ever raised the other warrant again. So our position would be that was abandoned by them at the trial court level, and therefore there's no need for remittal on that issue.
All right. Thank you very much.
All right, thank you, Your Honors. I line my briefs for all the other arguments.
Thank you. Mr. Ash, good morning.
Good morning, Your Honors. Ryan Ash for the people. The court appears very familiar with the arguments and the facts of this case, so the court doesn't have any specific questions.
The Jones issue on
Sure.
the first case, Mr. Talia does raise a good point. I had never realized this before, but it sounds like that Jones case says what he says it says.
Well, I don't agree with that, Your Honor, because the Jones case is saying essentially that in the home is not an element. So the people don't necessarily have to prove that before the grand jury. That's different than if they go ahead and do prove an extra element. You know, Jones is about what must be in an indictment handed down by the grand jury, not necessarily what evidence must be presented to the grand jury. And here, I would argue that, you know, legally sufficient evidence establishing all the required elements, and then in addition to that, not violating what is permitted or prohibited from being an indictment, but in addition to that, there's a special information which needed to be filed that, you know, alleges the possession. Previous instance, that doesn't go to the same thing that Jones is going to. Jones is about, you know, the minimum required. This is about.
So Jones says, you're reading the Jones is that the people don't have to prove that the exception doesn't exist.
Right.
Like there's an exception here for home. All they got to do is prove possession of the loaded weapon. It's up to the defendant to raise the exception.
Right.
But now we have an exception to the exception, which makes it so confusing.
It is. And
is this not like felony DWI where a prior conviction, you have to put that in to get an indictment for felony DWI? They say this is different. You don't need the prior conviction to get indictments for CPW 3 under the statute.
Right. Off the top of my head, I'm not super familiar with that statute, with the
Okay.
DWI statute. But yeah, I think that delineation is sort of borne out, not very well worded, but it is kind of borne out in the statute. But again, the thing about grand juries and even like, you know, actual juries who the trial juries hear the case is that there's sort of this back and forth about what to keep the jury in the dark about. And the grand jury is told in this circumstance, they're told the only elements of the charge are that essentially they possess a loaded weapon. And well, if you look at the entire statute, that's not all the subsections and not all the elements. We do find that the grand jury has only read a portion of the statute. And for us to say the grand jury was read essentially too much and was provided with too much proof is a fundamentally different kind of objection than the grand jury wasn't read enough. Therefore, the indictment is constitutionally invalid.
I guess, and you're referring to Hansen on that one, where essentially that as long as the proof is sufficient, then the indictment's not dismissible.
Right. It's not dismissible on a constitutional basis because the grand jury is there to protect defendants against being charged with, you know, crimes they didn't commit or charged with crimes that aren't really crimes, you know, being charged with something that it doesn't even amount to a crime under the penal law.
So this could have been a mistake to admit this evidence, but not a mistake that went to the integrity of the proceedings such that it's not forfeited.
Correct, Your Honor. I think that's a good way of stating it. Yes.
Well, but getting back to Justice Lindley's original question, so to be charged under this or indicted under this section, is that certificate of conviction necessary? The grand jury.
The certificate of conviction is not a legally necessary to satisfy a constitutional standard. It's not necessary that the grand jury hear that in every case. It is necessary in some cases.
But in this case, isn't it that defense's argument that it wasn't necessary, so all it does is bolster, you know, a likelihood that a proclivity to commit this type of crime, unless it's there to raise the similar to the DWI example that Justice Lindley brought up.
Well, I think that is true in the very abstract sense, but I don't necessarily think that's true in the standard that's actually applied to what evidence is given to grand juries, which even if we do assume there is error, then there has to be the potential for prejudice here. And that would rely on a lot of things, including that the grand jury can hear evidence that isn't admissible at trial often. You know, the standards for what's admissible at grand jury are different because they do serve a fundamentally different function, and the standard that they're examining the evidence is different. So to say that, you know, there's essentially too much evidence here because this wouldn't have been admitted at trial unless the defendant challenged it, I think that's kind of losing the grasp a little bit about the grand jury's constitutional role, which is the only thing that survives this guilty plea. So did I answer your question, Your Honor?
Yes, thank you.
Wish to be heard on 643 before you sit down.
I think those issues are well briefed, and I'll rely on that. Thank you.
Thank you. We are now going to go back to 647. I've been advised that counsel was here on both sides. 647, City of Buffalo versus Carr. We have two recusals. Justice Nowak and Greenwood are recused on this case. Good morning, Counselor. I called your case earlier. You probably weren't planning on being here right at 10, so my apologies.
My apologies, Your Honor. I'm usually very early. I tell my children 5 minutes early is 5 minutes late. I was a bit surprised, but I should have known because Judge Nowak initially went to the demolition of
Indeed.
these buildings.
Indeed. You may commence.
Thank you, Ray.
Thank you.
Good morning, Your Honors, and may it please the court. Quite possibly, the most important duty of any court is to protect the public. And this is enormously true with the Buffalo City Housing Court because they're charged with making sure that buildings are safe. What more do we have if a court doesn't make sure that people do the right thing to make buildings safe? In this case, where Judge DiTullio erred, was she considered this a normal, regular demolition? This was an emergency demolition. This building was falling down. The City of Buffalo housing inspector testified that he was afraid of a wall blowing out. I asked Tracy Krug, the housing inspector, well, what do you mean by blowing out? Bricks could blow out of the wall, and hit passersby. Right next to the arena in Buffalo, where hundreds and hundreds of people pass by for Sabres games and any other event at the arena. In an emergency situation, there's no need to exhaust administrative remedies.
Now, you may be right on that, but Judge DiTullio, as I understand her ruling, said she was bound by Judge D'Amico's prior ruling some 12 years earlier. Judge D'Amico in county court said that housing court lacked authority to grant a emergency demolition order in this procedural context. Right or wrong, the city argues that's res judicata.
I understand that here.
But so why are they wrong on their res judicata argument?
Well, Judge Pietruska said the exact opposite a few years prior.
Right. In a different case though, right?
In a different case, but in the same instance with an emergency demolition.
Right.
And
I will give you this. There are divergent opinions on this issue
yes, Your Honor.
all over the place.
That's why we need you.
Yeah. Well, they would say that we're bound in this case, the prior rulings on this case take precedence over the rulings in other cases. That's their argument of why it's bound. But we all recognize this is a very close issue. We know Judge Nowak went the other way back in the day.
I ran that hearing also.
Yes. So that's what it comes down to is, are we bound? Was Judge DiTullio bound by Judge D'Amico because it was ruling in this case, notwithstanding the fact that other judges in other cases went the other way?
Let's look at the Judge D'Amico ruling. He did not delve into the facts of the case. He did not address truly the emergency nature of the case. So when he said Buffalo City Court judges are not allowed to order a demolition at the request of a property owner who's being charged in Buffalo City Court, they have to go through the administrative remedies. I don't believe that he truly considered or enunciated the emergency nature of the situation. If this wasn't an emergency demolition, if a property owner just wanted to demolish the building, I'd have no case.
Did this become an emergency situation because your client really did not follow the notices for repair?
That's what the city would like you to believe.
It seems as though there's been a decade or more of failure of your client to exercise diligence in bringing this building into repair.
And that's what the city would like you to believe. He spent over $100,000 shoring up the building. The same company the city brought in to do I can't even call it shoring up, their stabilization, to attempt to stabilize after the most recent fire, was the same company he hired to shore up the building his first time in court. When the Judge Nowak case was going on, he did everything they asked. He sealed the building. We had a mothball agreement on the blacksmith building where the city would not further prosecute it if we kept it sealed up, and it's exactly what we did. The bricks in these buildings, the blacksmith building was a foundry. They're disintegrating from the inside out. There's nothing you can do to save them. Even the city's, preservation's expert for the city piggybacked on, because the other point is the city never submitted sworn affidavits opposing my motion. There's not one sworn pleading from the city saying.
They just say legally there's no jurisdiction here to grant us relief, regardless of the facts, I think would be their position. And I'm not saying they're right on that issue, but I think that's why.
I understand. I need to get over that.
Right. Since you brought up the fire, we have a subsequent appeal coming in October.
Yes.
My understanding is that the fire that apparently was started or erupted the day of the ruling here, Judge DiTullio issued a ruling against your client. Several hours later, a fire breaks out. As a result of that fire, it's my understanding that 4 out of the 5 buildings in one of the two properties has been destroyed and demolished already. Is that my understanding correct?
Not quite, Your Honor.
Okay,
What the city did, and it was an odd circumstance at the timing of the ruling. We had not received the ruling when the fire started.
right.
I remember
And
it's.
nobody's been charged, so I'm not
Yeah,
suggesting
yeah,
anything, but
exactly.
I'm just asking, is part of this moot now, given the damage from the fire?
I wish it were, Your Honor. I wish it were, but they are forcing stabilization of bare brick walls.
Even of the entire, both structures, every building in both structures?
Yes, Your Honor. Yes. I didn't want to submit additional evidence of the pictures right now, but to your question, there are bare walls left. So it is not moot. We wanted to go in after the fire and protect the public and move forward with progress and develop the site after the fire, but the city stopped us. The city said, no, we're going to do a protective stabilization, which, by the way, I see no authority for that in the statute. What I see in the statute on that issue is if a building is a wood frame building is damaged by fire at more than 50% of its value,
Right,
the
that's
city
for October. We're gonna,
must.
yeah.
Yeah.
We're gonna get into that in October.
And thank you. But that's a great point. The city must order demolition, and they didn't. So the city's relying on saying, if something is demo worthy and we need demolition, only the city can order it. They don't even order it when they must.
Now, the city condemned these properties. We were here last year on that.
Yes, Your Honor.
Um,
So I think that's the true motive, Your Honor.
so this, but they haven't commenced an Article 4 proceeding to acquire title yet, right?
That is correct.
If they did, it would be moot because it's their building.
Well, if they did, we would have a challenge to that because part of their condemnation is for historical purposes. And as you observed, there's nothing left. There's no historical purposes to a few bricks laying there and a couple walls that are being held up. Quite frankly, I'm amazed it survived the winter.
So your argument here, res judicata doesn't apply because there are if there weren't contrary rulings from Judge Piotrowski or anybody else, would res judicata apply?
I still don't believe so, Your Honor, because we have a change in circumstances. Because Judge DiTullio did not, or I'm sorry, Judge D'Amico, and then Judge DiTullio did not consider the emergency nature.
That is really your argument, right?
Yeah.
Things have changed and thus res judicata doesn't apply.
Yes, and quite.
Because there's new facts.
New facts, and look at the statute that created the Buffalo City Housing Court. Regardless of the relief originally sought by a party, the housing court may recommend or employ any remedy, program, procedure, or sanction authorized by law for the enforcement of housing standards if it believes it will be more effective to protect and promote the public interest. That's why we have the Buffalo City Housing Court. Their greatest charge, as I began with, is to protect the public. And they're stopping us from doing it.
So your point is that 12, 13 years ago, when Judge D'Amico made his ruling, the property was in a different condition than it is today. Judge DiTullio, the property when she had it, was vastly different. The city's contention, I believe, when council gets up here, is going to say the condition of the properties is irrelevant to the authority of housing court to order demolition. It doesn't, the ability of housing court to order demolition under this context, this procedural context, is not at all related to the condition of the property. That's their argument. What would you say if they argue that?
I would say it's 100% related to the condition of the property, as Judge Piotrowski noticed, as Tech Associates, as Judge Franzak noticed, all ordering demolitions when it's requested by the owner. It's absolutely related to the condition of the property. Quite frankly, res judicata doesn't apply if they can keep charging the defendant on new cases because of new conditions. That would stop the defendant any ability for them defending themselves. If the city can come in and argue new points and say, oh, but we already win, well, the property is different. Well, that doesn't matter.
I understand. Anything further, Counselor?
No, thank you.
Thank you.
Thank you.
Morning, Your Honors. Jerry Linehan on behalf of the city of Buffalo, and I think court's first point as to the res judicata, Judge D'Amico in 2011 stated that the Buffalo City Court does not have the authority in this context, in this situation, for a private citizen to seek this type of remedy. And that's been borne out through the duration of these proceedings. If you look at, all you have to go is through the first 4 pages of Judge Carney's transcript. That's part of the record. You know, not to put counsel on the spot, but he talks about it being Groundhog Day and being in front of Judge Carney again about 10 years later or so. And Judge Carney states, we are back here on Judge D'Amico's decision. And he says, on this actual case or on this issue, res judicata applies here. It's the same parties. It's the same property. It's the same it's the same argument and the argument is that the Buffalo City Court housing statute does not confer authority to this private citizen. And that's borne out too, if you look at the preservation code with the city of Buffalo. The preservation code of the city of Buffalo provides a remedy to a private citizen. It allows the private citizen to go to seek the permission with the preservation authority or preservation board. There is building permits that can be issued. There could be certificates of compliance, and it's a whole process. And if he wants to appeal that preservation board's decision to not grant that demolition, then he has the ability to go to the Common Council. He then can institute an Article 78 proceeding.
Because he did ask for that relief administratively and it was denied.
But he didn't go to the preservation board which is part of it's the code 337 in the
Deteriorated since Judge D'Amico made a ruling, and that puts us in a different context legally. And also there are contrary rules